Dear God in heaven, we thank you for this Sabbath. We thank you that we can come together and analyze prophetic messages and please bless us with understanding as we do that. Help us to use correct methodology, and might we be more settled into this movement and the messages that it has. We pray in Jesus' name. Amen. Before I start, I just want to say thank you to George for swapping with me this morning. I really appreciate it, and I'm looking forward to your study next as well. Um, so this morning is I was again, well, what am I going to present here? And I had a question that kept rattling my mind, and it was to do with Elder Terry's series of presentations on the Sunday law, Acts 27 and the Sunday law. There's there basically 8 presentations on that, and I I guess my question was, why did Elder Terry, particularly at the beginning, like the uh, presentation 1, 2, 3, and even touched on it in 4. My question sort of was the why was a large portion of those studies focused and devoted on voting rights? And so I I thought, oh, maybe I should, do a presentation on why I think the studies are valid and why, in my mind, they have strength and follow methodology. But I haven't done that. I'm not doing that. I thought Elder Shemaine's presentation, or 2 presentations, articulated for me what was rattling around in my brain. So I thought she did a good job with that, and had some basically her understanding was similar to mine, and the way she, even down to the point where she um, you know um, identified that the link with Millerite history with the calendar work. So it was a nice touch there as well. So that there was so I haven't done that, but what I am doing, I'm sort of reviewing, and like any review, this, when I was going through these presentations again and again, it just reminded me so much of Elder Tess's presentations, where it's almost overwhelming amount of information. Simple, it can be a simple message, but when you delve into it, it opens up into even a broader, almost an overwhelming amount of information. So I'm, even though I'm doing a review, I'm really only looking at a small part of, I would say, presentation 1, 2, and 3. So anyway, let's get into it. And I'm going to start, I'm not going to review Acts 27 or anything like that. All I'm going to do is, because where our question is, why the focus on voting rights? Why was there such a large amount of time on such an important set of studies at the, why was so much focused on voting rights and voting? And naturally, we have to go to where does it begin? Quintus Fabius Maximus Gurgis. So let's just remind ourselves what that means. I'm just going to abbreviate it and just say Q for Quintus Fabius Maximus Gurgis. So Quintus, or comes from quintilis, or the 5th month, or you're the 5th born. So I'm just going to say 5th, I'll just say month, or the 5th born. And then, so in application, that once you go from the Roman calendar to the Julian calendar, the 5th actually equals the 7th. So straight away, we've got methodology right there. The 5th equals the 7th. And that brings us to July. Which is the 7th month when you convert it to the Julian calendar. So Fabius, bean farmer. Equals, in application, voting. Okay. Because we're focusing on voting. Okay. So what was the year 2024? Globally, what was it known as?
The year of elections.
The year of elections. So a huge portion of the globe in democratic and not so democratic countries went to the polls. So 2024 was considered the year of voting globally. So, yeah, so we've got 2024 being a focus. We're not going to stop there because voting, it wasn't just, so here we are, 2024. We've been focused in on there. 7th, so we're in July of 2024. Let me just, I'll keep going with this theme. Actually, I was going to change, but I'll keep going with this. So coming back to here, quintilis, 5th equals the 7th. So the 5th president from the time of the end equals the 7th president. So right there's a prediction demonstrating what the 7th will be, how that's going to play out. And simultaneously, it's telling us about voting. So, and what we saw in July was we saw all the states, Republican states, because let's take a step back. When we go to quintilis, when we also convert from the Roman calendar to the Julian calendar, where it goes from the 5th to the 7th, it also marks Julius Caesar, because that is July, Julius Caesar. Caesar equals elephants. Elephants in July, the symbol of elephants is the Republican Party. So we've got the Republican Party marked in July. And what do that Republican Party, so what I'm saying is this is all keeps interconnecting and feeding off each other. So Quintus and Fabius, they keep sort of linking like this. So in July, we've got the Republican Party marked, and what are they doing? They are voting. What they're doing, they're voting in their primaries. Sorry.
I was just going to say they're voting for their nominee.
Yeah, they're voting for their nominee, for their presumptive presidential nominee, and the amount of pledged votes that have already been put forward is 272. So they've got 272 votes that have already been laid down to say, yes, Donald Trump is the presumptive, well, they've already got that. So there's, the more I keep looking at this, the more you sort of dwell on it, the more compelling it becomes. And I've watched it many times, but when you sort of really zero in on it, it's very difficult to draw any other conclusion. It's compelling. And also when it went from the Roman calendar, the Julian calendar, when it converted, you've got Julius Caesar marked also, and towards the end of his life, he was known as, I can't remember the Roman title for it, but it was essentially dictator for life. So there's so many points of interest centered around this moment. And also, one of the first things Julius Caesar did was remove, I can't remember the language now, I'm going off my memory here, but he stopped he stopped the voting of delegates. And so he then did that himself. He was the one that chose all the delegates as far as in the process in government. So one of the first things he did. And remember, these presentations were done quite a while ago now. We've seen this play out. So anyway, we're here to talk about voting. So why the focus on voting? So its history, or the origins of democracy. We saw a story of a global turning point. So that's why I put this up on the board. And this was in the presentation as well, one of the presentations as well. And I thought it really did a nice job of explaining something, and it taught me something I hadn't thought of before. And so let's just go over what we already know, because we've all reviewed this. We've got the history, we've got Eden to Eden model. We've got it two models on the one line though. We've got the model of progression and the model of restoration. The model of progression showing sort of an external I guess waymarks or points showing the progression of how information gets around or delivered or spreads. And we know that through the and it's what's interesting also, I didn't put this, but we've got that's supposed to go over there. We've got ancient and we've got modern. I know we say ancient Israel, modern Israel, but when you think of it from this perspective as well, it's almost like you got the ancient model or the ancient world's way of delivering information. Okay, so we've got written language now, we can pass a manuscript around. We've got roads and we need peace, Pax Romana, to enable that information to get delivered to where it's got to go. But there's a delineation between the ancient model and the modern model. And so there's a turning point, we'll call it. There's a turning point in information's ability to compound and go very quickly in a shorter period of time. And modernizing does that. Whether you're in a factory, you have 20 workers, now you can replace 20 workers with one machine. And it does it 20 times faster. So as we modernize, we'd expect the same compounding effect to occur. And so we can see the turning point for progression is the printing press. Now all of a sudden you can replicate the same piece of information many times, and that can be spread very quickly. And that then, obviously, then it gets to railroads, and the telegraph is more of an instant, nearly an instant mode of communication. So it's just getting better and better until we get to the World Wide Web. And now information is at the snap of a finger globally, and to the point where it just swamps everyone and there's that much information. Most of the world doesn't know what to do with it. So, can we see the turning point there? Now, we know that part. What I guess I didn't consider was, well, yeah, okay, that's progression. We can see progression and that's external. But what about restoration? Restoration internal, because it's about restoration. We've got three big problems that we start with. Three problems that need fixing. Sexism, worship, racism. We know that. Three big problems. How do we fix that? How does that problem get addressed? Well, we need a turning point moment for that to occur. Now remember, this is internal. So Elder Terry suggested that that turning point was the Magna Carta. Now why? Why would the Magna Carta be a turning point to start fixing those three problems? By the way, I didn't say this, but anytime anyone wants to say anything, you're quite welcome, as normal.
Because it's about human rights, Brenden.
Yeah. Yeah. So, and correct, that's as nice and as a simple answer as I think you're going to get. So, so back in the Magna Carta, there's an idea that was formed, and that idea says, sorry, King, and your government, you also need to be subject to law. And that's where the seed of democratic ideals was born. Whereby, I guess that seed, if you carry it through to its logical conclusion, everyone has value. So it's saying, King, it's not just your value above actually, if you're subject. So if I drew that model, just briefly, it's almost like saying, here's a king. There. The king, pre-Magna Carta, or the idea of a king. The king is the law. King equals law. The Magna Carta, the barons came in and said, you need to be subject to law just like us and everyone else. You can't just go in and do what you want to do. And so what happened, the idea of the model changed. And so that was over, let's just call them the barons. Let's just call it everyone else. Then the model changed. Hang on, you also need to be subject to law. So essentially, they've gone, hang on, you also need to be subject to law. And so the model now looks like, all right, so now we've got between human beings, I guess, the seed of equality, even though it was just barons back then, but you follow the idea through to the logical conclusion. And so okay. So the Magna Carta sought to prevent the king exploiting his power, I'll say his, and place limits of royal authority by establishing law as a power of itself. So it's like elevating law is not associated with you. Law is its own power. Okay, so now we've got law as its own power, and you, like all of us, are subject to it. And so 1st of July, first thing that happens, SCOTUS, presidential immunity. So what that did fundamentally was cut down the very idea of equality. In that one, it undoes the Magna Carta in principle. Now you're basically going whoop back up there. Because now the president is law. It's basically going whoop, straight back up there. Is everyone okay with that? So why is the Magna Carta a turning point to fix those three problems? It's because it was the seed, it was the turning point. It enabled the restoration of those three problems to be fixed. Because you go, oh yeah, but it's internal. Well, if you don't have, because we're focusing on internal, aren't we trying to fix that inside God's church? Yeah, but if you don't have an external mechanism, sorry, someone want to say something?
Finish your sentence. I didn't want to interrupt you.
That's all right, you go.
Question about how do you view that decision by the Supreme Court, how it was like wasn't full immunity. It's a certain type of immunity that's defined as specific actions taken related to their role as president. Do you have an opinion on that? I know a lot of news articles will say it's basically it grants him absolute immunity, but we know that when you look at it, it's not really that as such. Although maybe there are factions of the United States that would see it that way, and Trump may see it that way. Just curious on your perspective on that.
So, in principle, what will happen at this moment in time when that definition of, well, what constitutes an immunity, or what, I'm doing this in my presidential capacity to, I need to shoot my political rival because he's threatening democracy. So he's doing it in principle, what I'm saying is, okay, maybe I could have used better language, but in principle, that will just get kicked down to the lower courts, which will then go to the Supreme Court, and they will, in effect, they will do the same thing, because our prophetic model says that the three branches are overtaken. So
If
in
I
effect,
sum it up, sorry. I don't want to interrupt you. I just thought, is your view to sum up basically that it doesn't grant him absolute immunity, but the practical effects of that is that it's going to become so messy and difficult that basically the practical outcome will be effectively that. Is that
yes,
a way of summing up your
that's
view?
what I'm saying. So practically, he will be immune because it'll get kicked down. They'll say, no, you can't do that, Trump. He'll go and appeal. He'll go to the Supreme Court, and in effect, they'll already say what they've already said, and who's going to decide whether, in Trump's mind, I'm doing it in my presidential capacity or not.
Thank you.
And this is a really important point, and what I didn't say at the start is, hopefully I have time to go through to touch, because I'll tie this into Elder Parminder's first presentation in Wales, where he was talking about what is the agenda of the Supreme Court. And so when we delve into voting, I'm hoping we can start seeing the agenda of the Supreme Court. And when you start understanding what the agenda of the Supreme Court, you'll understand why I'm saying what I'm saying essentially, okay, there might be some technical jargon over here saying he is technically not immune to do whatever he wants, but practically that's what is going to happen. So I'm hoping we'll have a look at that anyway, and we'll delve into the Supreme Court a bit more and understanding why They are deciding the things they're deciding because Elder Parminter made a point that they're not against women's rights. They're not against, they also think disenfranchising voters is evil and terrible, but they've got something else going on in their mind that thinks something else is more important than. So it's like, and I'll draw a diagram later. It's almost like a tug of war in the Supreme Court, even in their own minds as conservatives, because they're deciding, well, what's the lesser of two evils? But we'll get to that. So the point here is the moment the ruling government or ruler says, I'm no longer subject to the law, instantly that breaks the model of equality, and it introduces and foments inequality. So essentially it's about the golden rule. The golden rule gets undermined. And what is the only mechanism there's only one mechanism that can fix this problem, and what is that? The problem is this. What's the only mechanism that we have in the world to fix this problem? Voting. That's the only delineation thing that humanity can do to fix that problem. So you need to vote them out. So voting is front and center on this whole argument. So why did Elder Terry focus on voting for a large part of her first three presentations? And she said this as well, because voting is the most important right we have. Because all other rights are dependent on or only occurred while we have access to free and fair elections and can take part in the democratic process. And Dobbs versus Jackson's Women's Health. The moment, we'll get into that, what happened, but the moment you start mucking with voter access and limiting people's access in the democratic process, everything's on the table. Now, I understand that, well, hang on, but didn't Trump just like win overwhelmingly and all this, or when I say overwhelmingly, convincingly win? All right, so I understand that as well. I'll park that thought. We'll come back to that. But we're dealing in the history of that at the moment. Okay. So I'll just summarize here. The Magna Carta also formalized a set of rights and freedoms that should be enjoyed. So it wasn't just about this law bit. It also it formalized a set of rights and freedoms that should be enjoyed. Yes, for the rich barons and wealthy widows, but the idea was there that it extends to everyone over time. So essentially, it was the beginning of rights, a charter of rights, human rights, which is exactly what Catherine said at the start. That would be expanded over time. So the idea of human rights was introduced, which is the golden rule. So to fix the problem of the fall of humanity, we needed a turning point to enable a restoration of the rights and the dignity of a human being, to bring about laws that will stop people hurting other people. And this is an environment whereby the golden rule can be restored in humanity internally and be fixed. Is everyone okay with that? Okay. So why did Elder Terry focus on voting for a large part of those first three presentations, touched on the fourth as well? We were given a history lesson of how the USA, I'm just summarizing what she went through, because I'm going to focus on a little bit. Why we were given a history lesson of how the USA had had a history of disenfranchising or limiting voter access through various ways. They're trying to make it difficult to people to vote until we get to the Voting Rights Act. So I've missed a whole bunch of information that Elder Terry went through. I'm going straight to the Voting Rights Act, the Voters' Rights Act. So that was introduced because of the Civil Rights Movement. So the Voting Rights Act was enacted in August 6, 1965, and it basically prohibited states from imposing qualifications or practices to deny the right to vote on account of race. So it permitted direct federal intervention in the electoral process in certain areas based on the coverage formula and required pre-clearance of new laws. So what happened? The Voting Rights Act said, all right, we need to ensure that everyone who wants to vote can vote as they want. Now, there was many areas, particularly there was certain states, I haven't put the list down, you can get the list online, the list of different areas and states who made it very difficult for African Americans to vote. And so essentially this Voting Rights Act got, I'll say, big government came in and said to not all the states, but certain ones that were causing problems and said, you now need special oversight because you're disenfranchising, you're preventing the citizens of this country from voting. All right, so, and it was based on a coverage formula, which I'll say it in a simple way without getting into it. Some areas were really efficient and surgical in the way they disenfranchised people. So they were put in a group on their own and they needed special, anytime they wanted to introduce any law associated with voting, that law would have to go through the oversight of the federal government, the Department of Justice, and that was, they would have to clear that law, not only, and it wasn't even about the intent of that law. It's like, well, you know, I have no intention of disenfranchising people. It doesn't matter. If the effect actually did the disenfranchising anyway, you could have the best intentions in the world, doesn't matter. If the law in any way, by not just intent, but effect, if it affected anyone's ability to access voting, it was stopped. And so what you've got federal oversight, and I'm using this language now to keep it easier down the track. Federal oversight into certain states' way they operate in voting, because the Constitution says states can run the voting how they want. So you can start seeing the tension build already. So like I said, some areas have been historically bad, so need extra oversight, and that's what this Voting Rights Act did. And the coverage formula, they had a methodology to address who should be in that list or not. Trying to find where I am in my notes. So the goal here was to protect minorities so they can freely participate in the democratic process without all the burdens of all these laws that have been introduced all through 100 odd years plus, and to stop any new laws from occurring as well. So essentially thousands of these laws since 1960, the 1960s, thousands of these laws have been stopped. So it never, the votes, a lot of these states and areas and regions didn't stop trying. It was an ongoing flood of laws that kept going. The only thing that stopped those laws going into effect was this. So I sort of answered it, but what type of government model do you need to provide oversight of this level? I'll just say big or small. You need a big government, a bigger form of government to provide oversight. So if we sidestep for a moment and we think about what Elder Parminder's last presentation was at, where's that? Where do they live? No, Wales. Okay. So what was it was all about Trump's cabinet picks and how genius but crazy they were. And what do they all have in common? What they all struggle, they're all skeptical of government. They're all running the government and they're all skeptical of it. And they want to reduce oversight. I mean, they're cutting their plans that are cut entire sections of the government. And then to have like an oversight, well, Elon Musk is part of that. Anyway, I digress. So I guess what I'm saying is the idea and the models that the current form of, or the presumptive, or the government that will come in January, they have a model that reduces oversight, whereas things like this, you need extra oversight. And this just goes all the way back to Vespers. All this was talked about in Vespers. So let's go into a bit more detail. Section 5 of the Act contains a pre-clearance requirement, and that requires certain states and local governments to obtain a determination, or also permission, by the United States Attorney General or a 3-judge panel of the United States District Court of the District of Columbia. And by the way, that was also the court, linking it into what we talked about before. That's also the court that said, sorry, you shouldn't have presidential immunity. It can't happen. And then the Supreme Court overruled that. So this is the same so 3-judge panel of the United States District Court of the District of Columbia. They're the ones that review all these voting laws or practices, and they're the ones that will stop those laws if they have an effect of disenfranchising voters. So the question is, how do you decide what area needs to be on the list that needs to get this oversight? So Section 5 is the pre-clearance requirement, i.e. it's got to go through those judges. It's got to go through the Department of Justice, the United States, Attorney General, via those 3 judges, etc. Okay, but then how do you decide who actually has to get that oversight in the first place? So Section 5 is a pre-clearance. Go to the judges, get permission to introduce the law in your state. But to decide who should be on that list in the first place is Section 4B. And that contains the coverage formula. and that determines which states and governments are subject to pre-clearance under Section 5. So if you're put in Section 4B, you have to comply with Section 5 and get pre-clearance on those voter laws that you're introducing. Okay, so since this was introduced, voting is all good. The coverage formula keeps getting renewed. Everything is going well, all okay, until when? Something happened, and that was Shelby Counter versus Holder in 2013. So, in a 5-4 decision, the Supreme Court ruled that Section 4B was unconstitutional because of the coverage formula was based on data over 40 years old and making it no longer responsive to current needs and therefore an impermissible burden on the constitutional principles of federalism and equal sovereignty of the states. What does that mean? What is this about? So, I'll share screen. Just make sure everyone can read that. Make sure it's up before I start. So, Shelby Counter versus, this is Wikipedia. It was a reasonable explanation, so I thought, let's just go with that. So let's go down to the opinion of the Supreme Court. So, essentially what happened, we've got Shelby County, which is in Alabama. So one of the states that is actually in 4B. They're the ones that have to comply and send anytime they want to change voting rules. They're the ones, this is an area district that had to send and get pre-clearance and permission before they were allowed to introduce it. All right, so they're going, oh, that's not fair. All right, so the Supreme Court struck down Section 4B as unconstitutional in a June 25, 2013 ruling. The majority opinion was delivered by Chief Justice John Roberts, joined by Justices Scalia, Kennedy, Thomas, Alito. The court held that Section 4B exceeded Congress's power to enforce the 14th and 15th Amendments. All right, so at the moment, I'll keep that simple. You've got the federal government, I'll say big federal government, defending a 14th and 15th Amendment, all right, to maintain, to ensure that voters couldn't be disenfranchised, all right? They're saying, sorry, that's unconstitutional. The reasoning that the coverage formula conflicts with the constitutional principles of federalism and equal sovereignty of the states, because the disparate treatment of the states is based on 40-year-old facts having no logical relationship to the present day, and thus is not responsive to current needs. Okay, so somehow you got the 14th and 15th Amendments in tension with federalism. All right, what's federalism? What if we use different set of words to federalism, what is that called? States' rights. Okay, so, and the states' rights are so essentially you've got tension here. States' rights are the 10th Amendment of the Constitution, and they also use Article 4. So you've got, so you can't just, so I guess what I'm saying is Elder Parminder said, you need to get into the mind or the agenda of the Supreme Court. What's their agenda? Because their agenda is not to reduce voting rights. They're not there. They say that's evil. All right? But they see something as even more evil. and we need to know what they consider is more evil, because every time they see something as even worse, generally there's going to be a fallout of equality somewhere. So their agenda is that they think something is even worse than, all right. And then you can see their reasoning. They're saying, well, okay, there was disenfranchising, 40, 50, 60 years ago, but come on, society's changed. We don't do that anymore. Okay. The court held that Congress cannot subject a state to pre-clearance based simply on past discrimination. All right. So when it states rights, there's also the 10th Amendment, or Article 4, also talks about you've got to treat, each state has to be treated the same. You can't have you can't treat one state preferentially to the other. But yet, what did this do? What did the Voting Rights Act do? It pinpointed certain states and said, sorry, but you need to do this. And so you can see that it's breaking the idea of federalism, because now the states aren't being treated equally, are they? They're zeroing on certain states, saying you now need extra big government federal oversight. And so as a state that now needs to comply with all these extra rules, how am I going to feel? I'm a victim. All right, so you can see the tension building. All right, we'll keep reading. Stop me at any point if you don't understand something, we can talk about it. Okay, so it's not responsive to current needs. So what they're saying is it's all outdated. The formula, by the way, it's all sitting in there ready to go. They can actually redo this, but the moment you say, they're saying Section 4B is unconstitutional, but the moment you say 4B is unconstitutional, you can't actually implement Section 5 because it doesn't work. They're saying you can't identify that area, that state, and that state. If you got that, you can't implement the pre-clearance voting laws. So until they and they've sent it back to Congress and said, well, you can renew it at any point, but until then it's unconstitutional. Okay, it noted that since the coverage formula was last modified in 1975, the country has changed. And while any racial discrimination in voting is too much, all right, so they're acknowledging you can't have any voter discrimination. Congress must ensure that the legislation it passes to fix the problem speaks to current conditions. The court declared that the 15th Amendment commands that the right to vote shall not be denied or abridged on account of race or colour, and it gives the Congress the power to enforce that command. So there's the 15th Amendment in tension with federalism or states' rights. What does that remind you of?
The freedom and equality, or maybe you mean the civil right, slavery era, similar.
Yeah. These arguments, the arguments in the history, in the antebellum history, leading right through the history of slavery, right through, the same arguments were being used. So this content in Elder Terry's studies is just a continuation of the Midnight Cry message. It's just saying, approaching it from a different angle, speaking to current events, and it's just continuing the same theme, same story, and extending. What else am I saying? Okay. The amendment is not designed to punish for the past. Its purpose is to ensure a better future. All sounds nice. Roberts wrote that the Act was immensely successful at redressing racial discrimination and integrating the voting process, and noted the US has made great progress thanks to the Act. But he added, if Congress had started from scratch in 2006, it plainly could not have enacted the present coverage formula. According to the court, regardless of how to look at the record, no one can fairly say it shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that faced Congress in 1965, and that clearly distinguished the coverage jurisdictions from the rest of the nation. Why? Why in the present scenario, back at this moment when they were considering this decision, why is he able to say, you look around, there's nothing approaching the flagrant, widespread, pervasive and ramping voter discrimination that faced Congress in the 1965. And why is that the case? Why can he say that? Because it's true. But why?
Would it be because a lot of the laws back then were explicitly and overtly racist? But these days, laws that have been passed are what they call like colorblind. They've found really sort of racially neutral ways to continue to discriminate. So it doesn't look like it's racist, but it is, in effect.
You've gone deeper than I did. So yes, I think in the context of this though, he's saying back then, look how bad it was. Now it's fine. Why? It's because the VRA was in place, and the Department of Justice is sitting there stopping the flood of laws. It's been stopping it for years, since 1965. It's stopped them, and it's stopped thousands of laws that tried to disenfranchise inadvertently, accidentally, intentionally, didn't matter. So this mechanism, all right, that they've just overturned, they've just said is unconstitutional. They've said it's fine, it's been fight for all this time. The reason is because Section 4B and Section 5 did its job. It stopped it. And of course you're not going to see the rampant discrimination that you presently see, not just in voting, but, you know, obviously we're in a line of progression, so it's more unpopular now to be racist, isn't it? So we've got to follow our progression model, which ties into what Ray just said there as well. So yes, I agree, Ray.
So,
But
Brenden,
from a
are
voting,
you basically, sorry,
go.
are you basically saying his argument has been like, job done, time to retire it?
Well, yeah, it's outdated. We've moved on as a society. We have progressed, not acknowledging that the primary reason that voters weren't disenfranchised is because the Voting Rights Act of Section 5, Section 4B kept stopping the laws. The day that this was overthrown, Texas immediately put in voter laws. Straight away, it started again.
And it's really interesting. Sorry, Brenden.
You're right.
That they're looking at the situation going, it's looking pretty good to us. So that's not where the disagreement is. The disagreement is on why it is better now. And on one hand, you've got it's the laws doing their job. So that's the reason it's looking pretty good. On the other hand, if it's not that, it's that, oh, we're pretty good people now. So that's why we don't need the law. And it reminds me a little bit of Lucifer's argument is like, we're pretty good. We don't need God's law, or even libertarians tend to think people are generally on the whole pretty good. And if you just give them the right education that they need, you know, you don't need the law. So it seems to me to tie into a couple of those other ways of thinking as well.
You can start seeing the model in their minds or the agenda in their minds. So just keep that there when we're going through this. Why are they making these decisions? Why? Why are they saying these things? And thank you, Catherine. I agree. All right. We won't worry about that. All right. So I guess we're in the history of RBG. So naturally, we're going to see a descent here. All right. And this is we're going to see Ruth Bader Ginsburg give us a parable. And I'm going to draw the parable because it just, in a few words, just explains what's going on in this whole history. So I'll just read it. Justice Ruth Bader Ginsburg wrote a dissenting opinion that was joined by Justices Stephen Breyer, Sonia Sotomayor, and Alina Kagan. This dissent would have held that Congress had sufficient evidence before it to determine that the coverage formula remained responsive to current needs. So they're saying there's plenty of evidence, by the way, that this is still needed. And before it got to here, I hope I'm not mixing up my mind here. I won't say that because I'm getting it mixed up with something else. So there's sufficient evidence that, actually no, I will say it because I'm pretty sure it's true. So before it got here, actually, no, I won't say it. I'll come back to that if I have to. Okay. Dissent. So RBG wrote a dissent. They've got sufficient evidence before it to determine that the coverage formula remained responsive to current needs. The dissent acknowledged that discrimination in voting has decreased in the covered jurisdictions since the Voting Rights Act enactment. Only because, sure, but if you know it's going to be blocked, why write it in the first place? But they're still doing it. So it has reduced, but because it's going to get blocked, even inadvertently. But it attributed much of that decrease to the act itself. Okay, so why has I guess voter disenfranchise decreased? It's attributed much to that decrease to the act itself. So it's because this is in place has stopped this disenfranchising voters. And this is what we're going to draw. She said, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. All right, let's draw that because here's an example of a parable that in a small diagram will explain what's going on. So here's the storm, rainstorm. Pelting with rain. So what's the rain? What am I going to call the rain? Let's call them voting laws. States.
Stop
On
your
that
shares.
spot. Oh, yep. Thank you. Throw it. I'll come back to that. So here's our storm. So what's the rain? All voting laws from the states who have in the 4B section, that they're the ones that need that extra bit of oversight because of their history and the formula that shows them why they need to be there. And it goes down to like census data as well. Like, you know, you could have a small percentage of population of African Americans who there's a percentage and there's only got a tiny percentage who are on the voter rolls. So there's something going on. Why is that? And so there's formulas that they figure that out. Okay, so we've got an umbrella. Whoop. Terrible. What's the umbrella? I'll call it the VRA, the Voting Rights Act, or Section 5 and Section 4B. We'll go 4B because that's the one they made unconstitutional. So that is stopping, all right? So what's this section? So it's all getting flooded. This is all dry though. So what's this section here? This is USA voting rights. This is the protected area. So why is this person not getting wet? Because of Section 4B of the Voting Rights Act is stopping all these laws coming down, and it's protecting the rights of voters so they don't get disenfranchised. So I'll just read it again. So I'll share screen again. Throwing out pre-clearance when it has worked and is continuing to work. Pre-clearance is the umbrella. It's working and it's continuing to work. To stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. So what they're saying is, the Supreme Court, the majority is saying, we're not getting wet. There's nothing to see here. Look, we're good. We've changed as a society. We don't need this in place anymore. And you know what? This is evil. Suppressing voting is evil. We don't want that. However, it's not that much of an issue anymore. So let's get rid of that. Reason it's not much of an issue is because that's in place. So she's very smart, as we know. So this here, this is where the Department of Justice or the judges sit there, and they're sitting up here protecting the people. They're up here vetting the laws. Nah, we're not letting that through. No. They're vetting, which is government, federal government oversight over the states. All right, so now, what's our time? Okay, we've got a few minutes. So what we want to try and do, we want to understand the argument of the Conservative Supreme Court. Okay. Office of Public Affairs. I'm going to share screen again. No. How do I get rid of that? There. Okay. Reflecting on the 10th anniversary of Shelby County versus Holder. So Shelby County, the county in Alabama. Holder, he was the Attorney General, the chief lawyer for the government at the time. Okay.
Or fed-
Federal. So you've got state going against federal. Holder is the Attorney General, and Shelby County is Alabama. So you've got states' rights versus too much federal oversight. That's my way of saying it. Okay. Let's just start here. All right. We'll look at some of this. We'll start here. One of the most important pieces of the Voting Rights Act was Section 5's pre-clearance requirement. Enacted in 1965, I'm just reinforcing again so it drops into our brain, and reauthorised by Congress in the 70s, 75, 82 and 2006. Section 5 required jurisdictions that had a history of voting discrimination to obtain approval from the Attorney General or a federal court before implementing changes in election procedures and practices. So I'm reading this because it's saying it in a different way than I've said it. Covered jurisdictions could not implement their proposed voting changes until they had received pre-clearance or authorization. Yet, that's not going to hurt anyone. You're good to go. Thanks to Section 5, jurisdictions that tried to make changes that had a discriminatory impact or were adopted with a discriminatory purpose were blocked from doing so. More than 800 proposed changes were altered or withdrawn in the period after 1982 alone. A repository of the Department's Section 5 objection letters, which provided an official record of each objection as well as the basis for the decision, can be found here. Let's not worry about that. The Shelby County ruling marked a significant turning point for voting rights in the United States. So they've identified this is a moment. In its decision, the Supreme Court invalidated or on constitutional grounds, not because they don't like voting and they want, you know, the Republican Party to win. That's not the argument. This is a constitutional argument, which ties into Elder Parmian's comments at the end of his first presentation in Wales. He's, you know, where our expectations of what we think prophecy is saying versus what we're actually seeing are two different things for a lot of people in the movement. So that's why he's saying you really need to delve in to the agenda of the Supreme Court as an example. Because they're not there trying to bring in sexism laws. Then that's not what they're trying to do. They've got in their mind compelling constitutional arguments. We need to know what their agenda is. Okay. The Supreme Court validated on constitutional grounds Section 4B of the Voting Rights Act, which provided the formula for determining which jurisdictions were covered under Section 5. Without that formula, all jurisdictions were released from coverage overnight. Section 5 was rendered effectively inoperative, freeing states and localities to enact voting laws without federal oversight. So it said, unconstitutional, sorry, federal government, it's unconstitutional for you to continue treating states differently. You're no longer allowed to do that because even though the evil of voter discrimination laws is terrible, it's not that much of an issue anymore. And you know what? What is even more evil is treating states differently, because that's even worse. You can't break the Constitution and unnecessarily burden certain states over others. In my mind, I just would have said, here's my quick ignorant fix, but I would have said, well, just make every state comply. Make everyone throughout the whole country comply. But anyway, I'll keep going. states wasted no time implementing election changes that had not or might not have survived the pre-clearance. So straight away, states have gone, woof, and they started throwing in laws that wouldn't have survived and wouldn't have got through just prior. Texas, on June 25th, 2013, the very day that the Supreme Court issued the Shelby County opinion, Texas officials announced that they would implement a discriminatory and burdensome voter identification statute. And on June 26th, the day after the Shelby County decision, Senator Tom, not sure, chairman of the North Carolina State Rules Committee, publicly stated that the North Carolina legislature would be moving forward with an omnibus law imposing multiple voting restrictions. In the absence of pre-clearance, now that we don't have the umbrella, in other words, the umbrella's gone, we've chucked it out, the statutes went into effect and the department, along with private parties, had to file a suit under a different part of the Voting Rights Act to try and got rid of them. So what it did, now the burden is on the other side to try and fight it through the courts. But it's crazy because by the time it goes through the courts to say that voting law it hurts people and it's discriminatory, you're talking years down the track. So the damage is done. So it almost becomes a dead law in practice, which is sort of what I was saying to Catherine before. They can do things that make it, in practice, it just doesn't work anymore. It's a dead law. Okay. All right, what's that? Okay. Let me close up. I just want to do one thing. I'll draw this and then we'll close. So essentially, we've got, this is the Supreme Court. It's almost like they've got a tug of war going on. All right. On one side, you've got the VRA. You've got 14th and 15th Amendment. All right. Pulling one way. Because voting discrimination is evil. It's terrible. So that's no good. On the other side, you've got the 10th Amendment. And Article 4. By the way, Article 4's history, out of interest, was the defence of the Fugitive Slave Act. But anyway, that was the defence back in that history. So they're going, what is the lesser of two evils? Well, there's not too much of that happening anymore, but this is way worse. So we need to prioritise that over that. And essentially what that's saying is we've got federal government oversight here, which is the law, and you've got the states, and you've got the rights of citizens or voting rights, individual rights. And so what they've done, they've basically prioritized that over that. I've rushed that, but I just want to get to some sort of point so we can close and we'll revisit it next time. So if you could join me in a word of prayer. Dear God in heaven, we thank you for the midnight cry that shook our values, our understanding of prophecy and events and the history we're living through. We thank you for that. Please continue and fulfilling that work in all our lives is my prayer. And we're grateful for the messages that you have given us, and we pray that you will please be with George next as he's presenting. Pray in Jesus' name. Amen.